And so anytime you want to talk, you just...
Subcommittee will come to order without objection. The chair is authorized to declare a recess of the committee at any time. Today's subcommittee hearing is about the administration's decision to end consideration of requests to defer deportation, including for critically ill children. We have a number of members who are waving on today, and we are delighted to have them. And without objection, I will wave on Katie Hill from California, Mark Desaulniers from California, Rashida Tlaib from Michigan, and Glenn Grothman from Wisconsin, all members of the broader Oversight Committee. I now will recognize myself for 5 minutes to give an opening statement. I want to welcome all of our witnesses and their families who've come from all over the country today, and I want to thank them for testifying, particularly Ms. Bueso, who is from Mr. Desaulniers' district in California, and Mr. Sanchez, who is from Ms. Presley's district in Massachusetts. It's hard to imagine what the past month has been like for you and for your families, and I appreciate your coming forward bravely to share your stories with us. I also want to extend my gratitude to Ms. Presley and Mr. Desaulniers for their characteristically excellent efforts to address this current turn of events, and I also want to thank our other witnesses, Dr. Danaher, Mr. Marino, and Mr. Homan for coming today. We are here to discuss the Trump administration's decision to deport critically ill children and their families from our country. This policy is completely at odds with American values. People come to our country to receive life-saving treatment from our pioneering doctors and hospitals and researchers, and we do not expect our government to implement life-denying policies. Last month, without notifying Congress or the public, the U.S. Citizenship and Immigration Services, USCIS, began denying all non-military deferred action requests. Most of these requests are made by sick immigrants and their families who are seeking to stay in the United States to receive critical medical care that is simply not available to them in their home countries. The administration decided to cast out some of the most vulnerable and defenseless people on earth. And there are families across America whose children would essentially be sentenced to death eventually by this stunningly harsh and cruel policy. Ms. Bueso, who's here today, was invited to the U.S. to participate in a medical study on her disease that extended her life expectancy by 10 years. To live, she relies on a weekly infusion that's unavailable in her home country, and she'll tell you about it. Mr. Sanchez, Jonathan, whom I've met, suffers from cystic fibrosis, a disease that my family knows well, and I am also the proud representative of the Cystic Fibrosis Foundation in Montgomery County, which has led a campaign that has absolutely transformed the treatment of cystic fibrosis and made America the leader in pioneering medical research and change in that disease. Jonathan's parents lost his older sister to the disease due to dramatically inferior and substandard medical care in Honduras, and he will tell you about that. And now they face the prospect of being sent back there. Joaquim Norville, a 7-year-old boy from Guyana who was in the United States when he suffered a seizure and was diagnosed with epilepsy. He was visiting his grandparents, who are U.S. citizens. Thanks to deferred action, his grandparents did not have to send him back to Guyana, where continuing treatment for his collapsed lung, colon infection, and the removal of his large intestine was essentially impossible. His mother fears that returning to Guyana now would be, quote, signing my son's death warrant. Serena Badia, a 14-year-old with a congenital heart condition, has already gone beyond the life expectancy given to her by doctors in Spain. I think actually Serena's 16. I'm not sure if I've got the right information there, but she'll correct us. An 8-year-old girl in Miami suffering from nerve cancer relies on her dad to take her to monthly treatments in New York. Her father needs deferred action to stay in the United States with his daughter. A man from Venezuela has been able to care for his wife, who suffers from a brain blood flow malformation, and his daughter has metastatic stage 4 neuroblastoma. The administration told him to leave the country this month or to face deportation. This new policy threatens sick immigrants who may be forced to leave America and end their life-saving treatment. It threatens U.S. citizens and lawful residents who rely on immigrant family members for financial and emotional support while they're here. It threatens crucial medical research and progress by undermining clinical trials that rely on the participation of immigrants with rare diseases, and we'll hear about that. The officials responsible for this policy must be held accountable for their recklessness and their failure to take even the most basic steps to determine the incalculable harm that would have resulted from this policy. The administration's decision to expel these immigrants was exacerbated by the limited time they were given to leave. According to medical experts, 33 days is not nearly enough time to even attempt to arrange for proper continuity of medical care overseas. For days, USCIS and ICE squabbled about who was responsible for the decision and how to implement it, and whether there was indeed a new process for stay requests. As they bickered, families were left in panic with all-consuming dread and terror. USCIS claimed that ICE would consider stay requests, but ICE denied those reports. The only recourse ICE offers would require vulnerable families to risk deportation before they can request a stay of removal. This is the unnecessary collateral damage facing every family caught between this bureaucratic tug-of-war between USCIS and ICE. It appears that no one in either agency contemplated or cared about the full implications of this change for the families involved. This administration's recent so-called reversal of the policy does not resolve the life and death consequences faced by many more families. After these heart-wrenching realities became public, the administration backtracked and announced that it would reopen all deferral requests that were pending on August 7. But there are still critical questions left unanswered. Will anyone who applied after August 7th be eligible for relief? Does the administration actually plan to grant relief to those who have reopened applications? What will happen to families that are currently receiving deferred action but will need to reapply once their 2-year stay expires? Without answers to these key questions, the administration's reversal appears primarily aimed at avoiding a tidal wave of criticism from the public. It gives the appearance of change without necessarily altering the essence of the policy. The administration must immediately and completely reverse this policy and continue granting deferred action requests in cases of the people who are here today and those like them. There are people who applied after August 7th who are still facing the 33-day deadline to leave America, a deadline that will arrive within days or weeks for some people. That's unacceptable. There is no justification for the incompetence of this decision, and there is no excuse for the recklessness displayed by our government in this whole affair. I look forward to having a serious and rigorous analysis of these events and a discussion of how we can all move forward together to repair the damage. It's now my honor to recognize our distinguished ranking member, Mr. Roy from Texas, for his opening statement.
Well, I thank the distinguished chairman. It's nice to see you back, to be back here. I appreciate the witnesses for taking the time out of your schedules and your lives for being here, and appreciate your testimony today. I think that as we gather here today, it is important to remember and reflect that today is September 11th, that we as a nation reflect on the tragedy of the terrorist attacks 18 years ago today. A number of us on a bipartisan basis gathered on the Capitol steps today in a moment of silence, and our hearts and prayers and thoughts are all with obviously those affected by it and the family members, but importantly also that we remember those who in the law enforcement community, first responders, people that ran toward buildings, and really just want to thank all of our law enforcement community, including you, Mr. Homan, and your life of public service and law enforcement supporting the United States. I would also, note that I want to thank the chairman for moving the hearing to today. There was some discussion of it occurring during August. Last week would have been very difficult for people to make it, so I'm glad that it's this week so we can have a better attendance. I think as we discuss this topic, and it's an important topic, that perspective is important. This past summer, we've seen obviously an unprecedented surge in migrants crossing into our country. We saw a growing humanitarian crisis at our border. At the end of August, apprehensions for the fiscal year are around 818,000, and we've already outpaced the total for 2018, which was 521,000. We've seen agencies such as Border Patrol and ICE struggling to fulfill their mission. The committee's held 3 hearings in the month of July alone on immigration and border security. And during August, I personally made a visit to DHS facilities in McAllen, Texas. I was pleased to be joined by my friend, the gentleman from Ohio, Mr. Jordan, as well as my friend from Texas, Mr. Cloud, to look and see what's occurring down on our southern border. And they're important conversations to have. As a member of Congress, as an American, as a Christian, we should be compassionate and do the right thing. We should help those in need. The question, though, is that we are a nation of laws. We're a nation of sovereignty, and we are willing. And, you know, what question I think is important to ask is, are we willing to send a clear message of what those laws are and then figure out how to navigate within a system of rule of laws so that we can understand how it impacts our nation, who pays for health care, and what the expectations are. My understanding, for example, is the average number of cases that we're just talking about today is about 1,000 a year, give or take. That's an important number. These are real people. And for each one of those 1,000, this is extremely important, and we need to figure out the right processes and make them work. But let's keep in mind, we're talking about 1,000 cases, and right now, as we've previously discussed, we've had almost 900,000 people who have crossed and been apprehended into our country since last October 1. That's an enormous number, of whom almost 600,000 have been caught and released into our nation. These are matter of fact. We've had a significant onslaught where CBP and ICE are trying to figure out what to do. We've got an overwhelmed system. USCIS is overwhelmed. The entire system is bulging at the seams because we, this body, refuse to do our job. Simply put, we're not doing our job to send clear signals and to make sure that the resources are there to adequately deal with the situation at hand. And let's think about the people who deserve our compassion. I think those people, all the people that we're talking about here, deserve our compassion, including those of those 900,000 I just talked about, who are abused on a journey because they're going through a tough journey with illicit, illegal organizations in Mexico, who are often in stash houses, who are often being held for ransom, women, girls abused on a journey, and we ignore that while we talk about how great open borders are for some reason in the false name of compassion, how good that is in our southern border. Let's talk about the 600,000 that were caught and released and are in a sort of perpetual cycle in the United States. Let's talk about human trafficking in this country that is getting worse because we're allowing illegal organizations to extend into our communities. And let's talk about the compassion owed to our law enforcement personnel, CBP, ICE, and other agents who've been overwhelmed and are being trashed on a daily basis by members of the United States Congress, trashed with deceitful and outright lies, disparaging these law enforcement officers doing their job. And today, though, as we discuss medical deferred action, I think we should ask some serious questions. Does the process we have work? Yes or no? Is anybody left outside looking in who doesn't know what the rules of the road are? Let's establish what the rules of the road are, and then let's follow them. And let's send clear signals as to what those are, and then let's operate in the right, humane and compassionate way to handle those questions. What agency is best situated to handle status questions for those seeking health care? Is it USCIS? Is it ICE? Is it anybody else? Let's answer those questions honestly and not hide behind rhetoric. Let's set a clear message. What are the rules? And then follow them. I'm encouraged today that the agencies are here to correct any information or misinformation about the current status of pending deferred action requests. My understanding is that USCIS has had 791 deferred action requests pending. Between August 7th and September 5th, denial letters went to 424 of those requests. All of those 424 claims have been reopened and will be evaluated and have received letters indicating that truth. Certainly love to know the question as to what happened in terms of the letters going out, how that occurred, and then now the reversal of that. I think we should look into that. USCIS did not issue any issue to appear NTAs for those 424 requests. That's what I understand. Since August 7th, USCIS has rejected 40 deferred action requests. Since September 5th, there have been no additional requests. So we can look in, make sure that's true. That's what I understand. Historically, USCIS has been the only agency to grant deferred action to someone not in removal proceedings. Deferred action can be revoked at any time. And when determining deferred action, no specific criteria or application was used. Field officers used their discretion in the totality of the circumstances to make a decision. I want to know, is that accurate? And when asked how the individuals who may have received deferred action came into the country initially, USCIS noted it does not track that data since there is no formal application for the process, and it's a mixed bag. I'd like to know. I'd like to track that. I'd like to understand it, and I'd like to know about it. And so now I think we'll learn from some of those things from the hearing today. So in wrapping up, I want to reiterate what I said in our July hearing. If we want real reform, real change, then we need to be discussing the root of the problem. The problem, in my opinion, is that we refuse as a Congress to stand behind the rule of law and make clear that our immigration and border laws are enforced. I think we need clear rules of the road, and I think we need to follow them. I think that is better for our nation. I think that is better for our sovereignty. I think that is better for the migrants who seek to come here. I think it is better for those who are sick, looking for care. I think it is better for a just and humane way of dealing with things. And I think we should stop sending mixed signals. I think we should stop sending signals it's okay to come here illegally, to stay over visas, to empower illicit criminal organizations and cartels, and basically have a system where we have indentured servitude in our country because we're allowing this broken system to continue. We just had 50,000 apprehensions at the southwest border in August. You see lots of news accounts saying how that's dropping down and how we should celebrate that. Well, it's still enormously high. It is still an enormously high number. We're still overwhelmed at the border, even as those decline in the heat of the summer. At the peak of the crisis, there were 132,000 apprehensions at the border. And so as this proceeding here continues today, we need to remember the underlying factors driving the crisis. We need to secure the border and do our job, and that all the pointing of fingers at the agencies and spewing of rhetoric here doesn't solve the problem, but rather real reforms start here in Congress. I want to thank the agencies for appearing today. I'd like to thank all the witnesses for appearing today and look forward to hearing from each one of you through the rest of the hearing. Thank you, Mr. Chairman.
All right, Mr. Roy, thank you very much, and I want to associate myself with your comments about 9/11, and I'm glad indeed that we were able to have a ceremony of all of the members of the House today observing this important remembrance. I now want to welcome our first panel of witnesses. It is my pleasure to have you here, and I thank you all for the great pains you've come to join us. The witnesses are Maria Isabel Bueso, Jonathan Sanchez, Shoba Wadhia, who is a clinical professor of law and the director of the Center for Immigrant Rights Clinic at Penn State Law School, Dr. Fiona Danaher, who's a pediatrician from Mass General Hospital, Chelsea Pediatrics, and Mass General Health Child Protection, Anthony Marino, the Director of Immigration Legal Services at the Irish International Immigrant Center, and Mr. Thomas Homan, the former Director of the U.S. Immigration and Customs Enforcement. For all the witnesses who are able, please rise and raise your right hands, and I will begin by swearing the whole panel in. And if you are not, please just raise your hand. Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show that the witnesses all answered in the affirmative. Thank you very much. Please be seated. Please speak directly into the microphones. You have 5 minutes, and without objection, your written statements will be made part of the record, so we will get a comprehensive look at what you have to say, even if you don't get it all in within 5 minutes. With that, Ms. Bueso, you are now recognized to give an oral presentation of your testimony.
I would like to thank the members of the House Committee on Oversight and Reform for this opportunity to speak before you and share my story. My name is Maria Isabel Bueso of Barrera. I'm 24 years old. I came to the U.S. from Guatemala when I was only 7 to participate in a clinical trial to save my life and the life of those like me. I came here legally and have been a legal resident in this country for over 16 years. But on August 13th, the USCIS sent a letter giving me and my family just 33 days to leave the country. But we were grateful to learn that our case will be reopened. Our future is still in question. This has been an overwhelming time for my family and me because the medical treatment I need is not available in Guatemala. I was born with MPS 6, which affects less than 2,000 people in the world. MPS 6 is a rare life-threatening disorder. My life expectancy was very short, and the doctor said I might not live into my teens. After the time of my diagnosis, there were no approved therapy to treat MPS 6. Then in 2001, I met Dr. Harman at UCSF Benio Children's Hospital in Oakland, who was conducting clinical trials for an inside replacement therapy. He was desperately needed more patients willing to participate in this research. I was selected for the trial, and my family was invited to come to the USA on B2 visa so I could participate in the study. As a young child, it was not fun spending so much time in the hospital, but I just understood it was an honor and a privilege. As I matured, it was rewarding to know that what I was doing was going to help a lot of people. I have continued participating in clinical trials until this day to help the next generation of the children with my disease. The first study I participated in was successful and led to the FDA approval of the first and only treatment. Thanks to this study, all the children with MPS 6 in the U.S. now have a safe and effective treatment that will help them live longer and have a higher quality of life. Doctors told me that if I stopped the treatment, my condition would decline quickly and I could die within months. So after the FDA approval, my family relocated to California so I could continue receiving this life-saving treatment. In addition to MPS 6, I also suffer from paraplegia and I use a power wheelchair for mobility. I have a tracheotomy and I have a baby shot in my brain, making my health care even more complicated. Still, the decision to relocate was hard. My parents left a middle-class life, their home, careers, family, and friends. My father is a computer system engineer and found a sponsor for an H-1 visa so that he could provide for us. In 2009, we petitioned for a change in status that we were granted deferred action for humanitarian reasons. We renew this status every 2 years, but this year, due to changing policy, our request was denied. I want to live. I'm a human being with hopes and dreams in my life. Despite my physical challenges, I have worked hard to achieve my goals. I graduated summa cum laude from Cal State East Bay and was director of the associate student for the Concord campus. I established a scholarship to support students with physical and mental disability at CSUAP, and I now work as an advocate for people with rare diseases. This summer, I was an intern at California Assembly Member Columbia District in Oakland. With an incredible support of my family, I have stayed positive and maintained hope through many struggles. I'm grateful for the opportunity this country has given me to receive medical treatment and to live much longer than expected. And I'm grateful for the humane immigration policies that have made my life here possible. And with that life, I want to make a difference for others. I'm asking Congress and administration to come together and to right the wrong of this changing policy. This is not a partisan issue. This is a humanitarian issue, and our life depends on it. Thank you so much.
Thank you very much, Ms. Bueso. Mr. Sanchez.
My name is Jonathan Eduardo Sanchez, and I'm a 16 years boy that has cystic fibrosis, a disease that affects primarily the lungs. Also, it affects the digestive system and my pancreas. I want to tell you about my life back in my natal country, that's Honduras, and how my life has changed since I came to the USA in 2016. I was born in Tegucigalpa, Honduras in 2003. I lived there for my first 12 years of my life. When I was 3 months old, my parents found that I had CF. It was a pretty scary day for them. It was a frightening because 3 years before I was born, they had a daughter named Samantha. She was born with a problem in her intestines. Unfortunately, the doctors in Honduras didn't know how to treat her or how to help her. 6 months and 2 days after she was born, my sister passed away. This was a pretty heartbroken moment for my parents. 1 month after, they noticed that she had cystic fibrosis. And right now, they're worried that if I go back to my country, it will happen the same thing to me. On the year 2016, we came to the USA legally with our tourist visas to search for a better cystic fibrosis treatment for me. When I go for the first time to Boston Children's Hospital in Massachusetts, they made me a pulmonary function test, and the results told me that I had only 40 through 42% on my pulmonary function test. The doctors of Boston Children's Hospital told my parents that I came to the USA literally dying. After the first visit, they sent me home with some of the CF medication that I should take, and that I wasn't able to get on my country. The first time I started to get into treatment, I got pretty tired because I wasn't used to it. The doctors, after they made me another pulmonary function test, this time it gave the answer of 60 through 69% on my pulmonary function test. Right now my baseline is 90 through 97. Right now I'm using a medication called Orkambi that helps like the cystic fibrosis mutation lives for a bit of time, but this medication is only on 2 countries, England and the United States of America. CF requires a daily home treatment that takes around half an hour, 2 hours if it is longer. This treatment is basically a precaution vest and nebulizers. I also take tons of medicines for my pancreas, my stomach, my lungs, and the other organs that are affected by cystic fibrosis. However, since we got the letter denying the medical deferred action application and telling us that we need to leave the country in 33 days or we'd be deported, my parents and I felt stressed, sad, scared, and mad. And it's incredibly unfair to kick out kids who are in hospitals or at home getting treatment to save their lives. The day our lawyers told us that the medical deferred action program was canceled, I started crying and telling my mom, I don't want to die. I don't want to die. If I go back to Honduras, I will die. After this, I feel so tired, both emotionally and mentally. I could not even sleep properly. I feel disappointed with the USA government that they canceled this program. Sorry for that. On my point of view, thinking that deporting sick kids like me, it will be a legal homicide because in our countries doesn't exist any type of treatment. Thank you for your time.
Thank you, Mr. Sanchez. Dr. Wadhia.
Ranking Member Jordan, Chairman Raskin, Ranking Member Roy, and distinguished members of the committee, thank you for inviting me to appear before you today. I am a law professor at Penn State Law in University Park and testifying in my individual capacity. My scholarship, teaching, and practice focus on immigration law, a field I have worked in for 20 years. I have published 2 books with NYU Press. My first book, Beyond Deportation, binds nearly a decade of research on the history of prosecutorial discretion and deferred action in immigration cases. My second book, Banned, examines immigration enforcement and discretion during the first 18 months of the Trump administration. Deferred action enjoys a long history in both Democratic and Republican administrations. First called non-priority status, deferred action operated informally for most of the 20th century. In the early 1970s, as part of his effort to support his clients, John Lennon and Yoko Ono, attorney Leon Wilds reviewed over 1,800 deferred action cases, many involving medical infirmity and humanitarian factors. In 1975, INS issued guidance on deferred action through operations instructions. In 1996, the operations instructions were moved into a new publication known as Standard Operating Procedures, or SOP. The 2012 SOP from USCIS describes how an individual, legal representative, or USCIS can request deferred action. Deferred action does not provide a formal legal status, but the legal foundation to use it is crystal clear. The immigration statute, federal court decisions, and legal opinions by INS and DHS have recognized the legality of deferred action. Regulations published during the Reagan administration explicitly identify deferred action as one basis for work authorization. USCIS has used deferred action in medical and humanitarian cases for decades. The idea is longstanding and, in fact, customary. In one data set I received in 2011, nearly half of the cases I could identify involved serious medical conditions, and many of the cases involved more than one factor. For example, deferred action was granted to a 47-year-old schizophrenic who overstayed his visa, was the son of a lawful permanent resident, and had siblings who were U.S. citizens. Over 100 of these cases involved people whose homes were destroyed by an earthquake in Haiti. In another data set of 578 cases obtained from USCIS in 2013, 336 were based on medical issues. One case involved a Mexican female who entered the United States without inspection and had 2 U.S. citizen children. One of her children had Down syndrome, and the other child had serious medical conditions. I received a third data set from USCIS in 2016, again revealing that many deferred action requests were based on serious medical conditions. The data set included a child with burns on over 65% of their body and parents of USC children with cerebral palsy. USCIS has a long history and the expertise of handling cases for vulnerable populations and should continue to process humanitarian deferred action cases. Preserving an affirmative deferred action process at USCIS allows a person to request what is often a life-saving protection without having to undergo removal proceedings, and also saves the government resources. Further, nearly every legal opinion from INS and DHS on prosecutorial discretion instructs officers to exercise prosecutorial discretion at the earliest stage of the enforcement process. Stripping USCIS of jurisdiction over deferred action forces a non-citizen to instead exhaust the enforcement process. Who is served by placing a cancer patient who might ordinarily request deferred action at USCIS into the removal process? No one. Finally, USCIS should improve transparency by publishing statistics about deferred action and providing greater notice and information to the public.
Thank you, Dr. Wadhia. I'm afraid your time is up. We'll have further time for questions. Dr. Danaher.
Ranking Member Jordan, Chairman Raskin, Ranking Member Roy, and distinguished members of the committee, thank you for the opportunity to testify before you today. I am Dr. Fiona Danaher, a pediatrician at Massachusetts General Hospital for Children, where much of my clinical work focuses on the care of children in immigrant families. I have come here today to express the profound concerns that I and my colleagues share over USCIS's potential termination of the Medical Deferred Action Program. Our hospital cares for children who have benefited from the program, including a young child with a rare genetic condition that causes seizures and developmental challenges. In the country of origin, this child's condition is stigmatizing and deemed unworthy of care. The family was told the child would suffer from intractable seizures and die within a year. Refusing to accept that nothing could be done, the family left everything behind to seek a second opinion at Mass General Hospital's specialized clinic devoted to this genetic condition, one of only a handful of such clinics in the world. Thanks to the family's determination and the care of a dedicated clinical team, this child has lived a longer and much richer life, attending school and achieving some mobility and social skills. None of this would have been possible without the Medical Deferred Action Program. Now the child's status is due for renewal at a time when the program may arbitrarily end, jeopardizing much hard-won progress. When pediatricians care for medically complex children, we often do so with bated breath. These children are by definition vulnerable. Whether they suffer from cancer, cystic fibrosis, muscular dystrophy, cerebral palsy, or one of any number of other diseases, they require care from a multidisciplinary team of specialists. Depending upon their underlying condition, An error as simple as a misdosed medication, a dislodged tracheostomy breathing tube, or a poorly covered sneeze could spell catastrophe. For many of these children, their health is so tenuous as to make travel unsafe, and their clinicians would hesitate to even transfer them to another hospital within the United States, never mind overseas. Should these children be forced to return to their home countries, their care may be impeded not only by stigma and misunderstanding, as in our patient's case, but by lack of basic resources. Access to safe food and water is not a given in many parts of the world, and chronically ill children routinely die from malnutrition or infection as a result. Unreliable electrical grids threaten the health of children who depend upon interventions such as pumps, ventilators, or medications that spoil without consistent refrigeration. Particularly frail children can die from heat-related complications for want of access to air conditioning. Severe air pollution in developing countries poses a dire hazard for children with underlying lung disease, and immunocompromised children are poorly equipped to handle exposure to endemic infectious diseases such as malaria, diarrhea, measles, and pneumonia. Healthcare systems in many low-middle-income countries are still in their nascence. Simply transporting an acutely ill child to a hospital can pose an insurmountable challenge in areas without ambulances or safe roads. Supply chains are inconsistent, so should the child make it to the hospital, the medications and equipment he or she needs may still prove unobtainable, as may the skilled personnel needed to administer them. It is sadly not hyperbole to say that sending medically fragile children to such environments amounts to issuing them a death sentence. Adding insult to injury, such children could find themselves unable to access even the most rudimentary palliative care to ease the anxiety and physical pain of their passing. Perhaps no intervention is more crucial to minimize the suffering of a severely ill child than maintaining the presence of a loving family member at the bedside. Terminating the medical deferred action program would leave some medically complex U.S. citizen children struggling not only with the physical burden of their disease, but with the emotional trauma of forced separation from their immigrant parents. No child can be expected to heal under such circumstances. This is not just bad medicine, it is unconscionably inhumane. The U.S. Department of Health and Human Services building here in Washington, D.C. bears an engraved quote from its namesake, Hubert H. Humphrey. It reads, "The moral test of government is how it treats those who are in the dawn of life, the children, those who are in the twilight of life, the aged, and those in the shadows of life, the sick, the needy, and the handicapped." My colleagues at Mass General and I respectfully urge USCIS to embrace the moral imperative of permitting our young patients the opportunity to heal and to thrive. Thank you.
Thank you, Dr. Danaher. Mr. Marino.
Chairman Raskin, Ranking Member Roy, Ranking Member Jordan, distinguished members of the committee, thank you for inviting me here today and for hearing these stories. I'm here today in my capacity as the Director of Legal Services at the Irish International Immigrant Center, where we provide legal, wellness, and education services to immigrants from Ireland and 120 countries around the world. In our legal program, we have represented dozens of families facing the horrific circumstances that always accompany an application for deferred action. In the majority of deferred action cases I've seen, an individual entered temporarily and then fell ill, was gravely injured, or received a terrifying diagnosis. Sometimes the illness or injury makes travel impossible. Sometimes life-saving treatment is just not available in a home country. In the vast majority of cases we handle, it's a child whose life is at stake. We represent children with cerebral palsy, muscular dystrophy, a child blinded by the cancer in her eyes, a child who is suffering multiple seizures every day. We represent children confined to wheelchairs, connected to feeding tubes and tracheostomy tubes. And in each of these cases, there's a family with no desire to break any law, but who simply cannot leave without putting a life in danger. And in these kinds of dire circumstances, the government has always provided a relief valve, a process by which a family could come forward rather than cowering in the shadows over a sick child and lay out their circumstances, explain to USCIS why travel had become impossible, even deadly, and that the government would agree to allow them to continue their child's care. I know that lives have been saved by this program. I've sadly also known children we've represented to die in this program, but even in those cases, the brief reprieve by the government bought those families precious time. This long-standing legal program is what protects people from government actions that would shock the conscience and betray our fundamental values as a nation. I was shocked then 3 weeks ago when I received the first denial notice, and over the course of the next 2 weeks, about a dozen more. They all contain the same boilerplate language. USCIS field offices no longer consider these applications at all. Leave in 33 days or we may initiate your removal. The decision to terminate the program was done in secret. There was no prior notice, no opportunity to advocate for the program, and no opportunity to prepare my clients for those denial letters. We immediately reached out to all the families who were applying or were in the program already, and I've had some of the most difficult conversations of my life over the past few weeks. Clients have asked me what the government expects them to do, to disconnect a child from life-saving support, to put them on a flight that they may not survive. They've asked me what I would do. And we file many applications for parents whose U.S. citizen children suffer these life-threatening diseases. And in these cases, the termination of the program threatens yet more family separation. There are parents right now having conversations about whether to orphan a child in order to extend his or her life. When the terrible reality of what they had done became public, USCIS's initial response to the media was to deny that they had eliminated the program. They claimed they had simply transferred it to ICE. And of course, our clients wanted to know what that meant and how much danger their families were in. Media outlets were contacting our center trying to get us to explain it to them, and I had to tell them that the only information I had, I was getting from them. But the transfer to ICE appears to have just been false. There's no new procedure, there's no new program, and ICE officials have since confirmed, again through the media, that they have no program in place and no plan to implement one. After USCIS's latest press alert last week, we began receiving notices that some cases would be reconsidered. We still don't know what that might mean for those families. The press alert references Department of State regulations, and it's unclear if this means they're applying the same standard they always have or if they've made up some new standard that we don't know. And the press alert and these reconsideration notices we've received still indicate that the program has been terminated moving forward. It leaves no option for families in these dire circumstances now or in the future. Because the program was terminated in secret, people didn't know, they kept filing. We've filed applications as recently as August 16th, and we have no idea what it means for that case. Deferred action is a critical, literally life-saving program that impacts a small number of families, but in an absolutely immeasurable way. And ultimately, USCIS hasn't backtracked so much as doubled down. They've delayed the consequences of their decision for a handful of families, but that's it. And unless Congress or the courts can either convince or compel USCIS to reinstate the program, everyone in it and everyone that would otherwise benefit from it is in a horribly worse position today.
Thank you very much for your testimony. Mr. Homan.
Chairman Raskin, Ranking Member Roy, and distinguished members of the subcommittee, thank you for the opportunity to appear here before you today on this very important subject, which is the appropriate exercise of prosecutorial discretion. My name is Tom Homan. I'm a veteran of the nation's immigration service. I retired in 2018 after having served more than 34 years in enforcing immigration law. As you know, I'm passionate about this issue, and I'm glad to be back to testify on a different aspect of it today. But before I delve into the details pertaining to the subject of today's hearing, I would also like to pause to reflect on this being the 18th anniversary of cowardly 9/11 terrorist attacks on our homeland. May God have mercy on those innocent victims who lost their lives and their families, and may we continue to protect this country against those that want to destroy us and the freedom we enjoy in this country. I also want to salute and honor the fallen soldiers that took the fight to those who attacked us and made the ultimate sacrifice. I, for one, will never forget. Regarding today's hearing, I would like to start by clearing up what appears to be a common misunderstanding. It is not lawful to have a deferred action program at any federal agency. The word program conjures the idea that an entire class of aliens, if they meet certain criteria, are entitled to a benefit, in this case, deferred action. That is simply not the case. When you break it down to the most basic underpinnings of the law, deferred action is the exercise of prosecutorial discretion, and prosecutorial discretion, whether it's a stay or removal, deferred action, administrative closure, may only be exercised, one, on a case-by-case basis, and not for a class according to a set of criteria, and two, by law enforcement agencies. Again, prosecutorial discretion is rightfully only exercisable on a case-by-case basis, and even then, only by the relevant prosecuting agency, a law enforcement agency that has the statutory authority over those laws. And I'm here to answer those questions about that program today. It's an important hearing, and these are important questions we'll be talking about today. But I want to change the course here for 1 minute. I understand this hearing is very important. That's why I accepted the offer to come here today and discuss it with members of Congress and American people. Any policy that affects lives is important. One death that could have been prevented is too many. But I must voice a concern what I have about these types of hearings. I have noticed that the House is quick to schedule hearings whenever there's a policy change or an operational change that some think, and usually they're wrong, that this change may negatively impact someone that knowingly violated our laws and may be in the country illegally. I don't see the same sense of urgency when existing policies put our citizens in danger, puts this country's security in danger, or results in an unsecure border, which results in not just a humanitarian crisis, but a national security crisis. While we continue to have hearings which contain inaccurate titles, misleading titles that only serve to push a false narrative about the actions of this administration and vilify the brave men and women that serve within this administration, you are choosing to ignore a bigger problem that affects many, many, many more lives, many more than this recent policy change. If you want to affect meaningful change that will save countless lives, you need to refocus and add to this hearing today. For instance, where are the hearings to discuss the crisis on the border and the 3 loopholes that are causing much of the crisis? Where are the hearings on the existing loopholes or on the asylum laws that are being abused? The TVPRA that is causing many children to be put in the hands of criminal organizations and put at great danger? Where are the hearings concerning the Flores settlement agreement that has resulted in unprecedented flow of family units that have resulted in countless child trafficking victims, 32% of women being sexually abused, and children dying? Criminal cartels are making millions of dollars a year because of congressional inaction. But I see no hearings on this. These same cartels that have murdered Border Patrol agents. Where are all those hearings? This humanitarian crisis has caused a national security crisis because half the Border Patrol is no longer on the front line. Where's that hearing? You want to conjure up a false narrative about sending dying children home, but you won't address sanctuary policies that provide sanctuaries to criminals and put our communities at risk. Many children and others have been raped and murdered by criminal illegal aliens after being released from a sanctuary jail. But I don't see a hearing on that. Thousands of angel moms and angel dads have been born out of sanctuary policies, but I don't see the urgency that we have on things that we want to attack the administration on. I don't see a hearing on that. Our nation's heroes in ICE and Border Patrol are under attack. Their families are being attacked and bullied in public, in churches and at schools. Even companies that work with us are under attack, and their lives are being threatened. Where's the hearings on that? I hear nothing but dead silence on this issue. What I do hear are members of Congress joining in on the hate. Truly unbelievable. I ask that you step back and take a breath. Attack this administration a little bit less and actually address the underlying problems that have caused all these problems. Do your job and fix the loopholes. Make hearings meaningful and actually take some legislative action after the hearing rather than staging more political theater. No member of Congress should be against securing our border. There's no downside of that. There's no downside to less illegal immigration. There's no downside on less illegal drugs. There's no downside in taking money out of cartels' hands that have murdered our agents. Today's hearing is important. I want to make that straight. This is a very important hearing. We need to discuss it. I'm glad to be here, but we need to talk about these other issues down the road.
Thank you, Mr. Hummon, for your testimony. We will now begin the period of questioning from the members, and I will recognize myself for 5 minutes for questions. On September 2nd, after the subcommittee demanded USCIS and ICE appear at this hearing, the administration announced a partial reversal of the new policy. In particular, USCIS stated that it would, quote, reopen requests for deferred action that were, quote, pending on August 7th, 2019. Ms. Bueso, you and your family were told by USCIS in a letter dated August 13, 2019, that you need to leave the country by September 14th, which is this coming Saturday. I'd like to put the letter up on the screen if we could. In the meantime, quickly, let me just ask you a question, Ms. Bueso. You were recruited to participate in several clinical trials, is that right?
That's correct.
So you are here both for your own treatment, but also to participate in these trials that could help everyone suffering.
Many clinical trials help other people.
Okay, very good. Now, if we look up on the screen, USCIS says if you fail to depart the United States within 33 days of the date of this letter, USCIS may issue you a notice to appear and commence removal proceedings against you with the immigration court. Was your request submitted before August 7th, 2019?
We sent our package on May.
I'm sorry?
On May.
In May, in the month of May, okay. Have you received anything from USCIS about your case since this letter came on August 13th?
No, we received that letter on August 13th, 16th, and then we got another letter from the USCIS that they were going to reopen it, but it's still uncertain, the situation.
Okay, so you got a letter saying it's been reopened. So,
But it's uncertain, it's not clear.
but we don't know what that means.
Yeah, we don't know what that means. And I have here my lawyer, Martin. He can answer your question, too.
Okay. USCIS, as I understand it, has not explained to anyone what the practical implications are of this partial reversal in the wake of public protest about what had happened, including whether any requests submitted prior to August 7th would eventually be approved. Mr. Marino, in light of this putative reversal, what concerns do you have for people who requested deferred action before August the 7th?
Yeah, I wouldn't call it a reversal because the press alert that USCIS issued still indicates that they've terminated the program. They just said they're going to finish the cases that were pending on August 7th. So I have clients with sick children now who need access to this program and aren't able to file.
Okay. Mr. Homan had advised against using the idea of a program, saying this is just selective case-by-case granting of the deferral. What's your response to that?
Yeah, I don't see the distinction. There are lots of programs that are that have individual discretionary decisions made in them.
Okay.
There's a standard operating procedure for it. If he doesn't like the word program, that's fine. But
do you feel confident that requests like Ms. Bueso's will get a full and fair review from USCIS?
I certainly hope so. I'm remaining confident. I've told my clients I hope that those that they will consider will get the same consideration that they've always gotten in the past.
Okay.
But this language in the press alert about some State Department regulation, we're not sure what that means. So
There's even more uncertainty about the future of critically ill kids whose families submitted requests after August 7th.
Right.
What's going to happen to immigrants and families who fell on the wrong side of this August 7 deadline?
I have no idea. We've filed at least one case after that, and we've received nothing. So we didn't receive a denial. We haven't received anything about new procedures being in place. We just don't know.
And these are people who are in relatively similar circumstances in terms of critical medical situations?
Yeah, so I have about 19 families that we represent, and they're all critical medical conditions.
How would you describe their mental condition given the legal uncertainty?
It's been absolute chaos. People are terrified. We've had more conversations in my office with crying clients than ever in history, and that's a big thing to say in an Immigration Legal Services office. It's been devastating. People are terrified. It's their children's lives.
Dr. Danaher, let me come to you. What is the attitude of doctors, nurses, medical personnel, given the current context about what's happened?
Frankly, we're rather appalled. These patients are incredibly sick, and they need care, and we'd like to provide it for them.